Okay.
Okay.
Laura, you're on mute.
You're on, yes.
Okay, how's that? Good evening, everyone. We're calling to order the meeting for the Zoning Board of Appeals for the town of New Canaan. Will come to order on October 4th, 2021. I'll explain to you how this will work. When your case is... Did someone say something? When your case is called, we're going to ask that you identify yourselves and the property in question, state your request of the board, and identify your hardship and the reasons for the request. Remember, your hardship cannot be financial in nature, and it runs with the land. The board will then ask you questions, after which you will be able to, the others will be able to present. You will then be given an opportunity once again to summarize your request. We'll ask if there are anyone in the audience that is in favor of the variance and any people in the audience that are opposed to the variance. The board will then go into business session and discuss and make a decision. There are 5 voting members of the board, and it takes 4 positive votes for a variance to be granted. I understand that we have 27 Park Place is a continuation from our last meeting. Lynn, can you take roll for us so that when we'll get started?
Sure. Laura Edmonds.
Present.
John Mahoney.
Present.
Jessica Cardone.
Present.
Luke Toshjian. Luke Toshjian.
Sorry, I was muted. Present.
Becky Walsh.
Present.
Richard Caratu.
Present.
And Cynthia Dull.
Present.
Everyone is here, Madam Chair.
Okay, I have in my notes that Becky is seated from the last time for Ben. So we'll keep that, we'll continue on with that. I know, Lynn, that you mentioned that you were going to discuss an addendum portion before we started. So can you talk to us a little bit about some of your findings?
Sure. So last month there was a question of whether there was a need for an additional variance of section 6.9B2. So I just wanted to add some clarity to that conversation. So in section 6.9, there are 2 illustrations. One illustration, the first on the page when you look at the hard copy, is really to clarify 6.9A. And the second illustration is to clarify 6.9B, and it appears on the second page, not the page where all the text appears for 6.9B. The first, in 6.9A, it's a discussion of visibility at intersections. So when intersections abut with an access way, or an access way abuts with an intersection with a street or a right of way, this isn't the case here. Section 6.9B discusses driveway obstructions, and in 6.9B, 6.9B is essentially to provide room and access for emergency vehicles to get into and access buildings and parcels within New Canaan. 6.9B1 discusses the width of the driveways and notes that it should be 14 feet wide as an unobstructed width. And 6.9B2 notes that nothing can be built within the either side of the driveway when it intersects with its intersection with the right of way. And here in this case, for 27 Park Place, they're looking for a variance for the width for 6.9B1 of the, and if you were to look at the survey, and I can actually bring it up. Hold on one second. So when you look at when you look at their survey, and I'll bring it up. This is their proposed driveway is here, where my cursor is. And they're proposing to put the driveway against the property line. And in this case, there's no obstruction on their side of the driveway where at all, and they're against the property line. And if there's an obstruction on this side, you can't grant a variance for the neighbor's property. And so it's moot what's on this side at the end of the day, unless you guys determine that that's a problem. And the ZBA, you have to determine whether you're going to grant or deny a variance. And at the end of the day, the applicant is going to go to the P&Z for the distance to the property line, which is 3 feet. And that's all I have.
Lynn, so they need a variance from 6.9B1 and B2 because the driveway is not 25 feet. There's not 25 feet opening at the end.
No, they need it from just 6.9B1, which would be the width of the driveway. And for only the portion that can provide the unobstructed 14 feet access. The 25 feet would be a distance along outside of the driveway. And it would only, on their side, it would apply. But I mean, you guys would have to make a determination on this side. They're proposing to locate the driveway adjacent to their property line.
But say, for instance, if there was a pole on the, I don't see the arrow here, the way the screen is. I guess it's on the north side. This screen's rotated weird. If it's on the south of the line, right, I think the south, on the bottom of your picture, that pole, that's an obstruction. SNET number 32 is an obstruction within that area that has to be clear, you're saying. So they would need a variance.
This is the neighbor's property. It can't be considered as, I mean, you can consider it as part of your discussion, but it can't be considered. You can't grant a variance for the neighbor's property.
That's what I'm saying. So how can they ever comply with this if without us granting a variance
It's
of the
their
neighbor's property?
It would be on. It would
Because the
be
25 can't be all 25 feet going north. The 25 has to be 25 feet centered on the driveway. That's the illustration shows.
Yeah, but then you can't grant a.
So then it means we can't grant this variance, you're saying then? Because they need 25 feet centered on the driveway. It can't be 25 feet just heading north.
So that you can't consider what's on, I mean, you can consider what's on the neighbor's property, but you can't grant, you can't, they can put the driveway in the location they want if they get the variances from the ZBA and from P&Z.
But they would need a variance from 6.9B2 because they're not having the 25-foot opening at the end.
No. So that what's on the neighbor's property is already built. You can't change that. That's the neighbor's property. But in what they can control.
I know, but this is why you couldn't theoretically have the end of it within, if it's 12 feet and you need 25 feet, then I mean, if it's 14 feet and you need 25, you need 9 more, which means theoretically you couldn't have it within 4.5 feet of the driveway ever, because you'd always be granting a variance over the neighbor's property, which you can't do.
So that's I mean,
it makes it an impossible application, you're saying then, because we can't grant a variance over the neighbor's property. So how do we count that 4.5 feet? We can't, you're saying.
Yeah, you can't count what's on the neighbor's side.
So it's impossible for them to meet that 6.9.b.2 you're saying.
But they're not asking for a variance of that. They're only looking for the variance.
But
of
the
width.
driveway is not going to comply with that.
They can't, their driveway, so this is for access, and it would be on, if they were putting the driveway in the center on their property, if they were locating a driveway and they could provide access, the neighbor's property line is there. That, I mean, that ultimately that would color your decision if that's the.
Well, this prevents you from putting it, if you can't count the neighbor's property, and this prevents them from having it be within 4.5 feet of the neighbor's property, essentially.
Well, that's what they're requesting a variance of when they go to the commission, because they're asking for distance, the dimensional distance from the property line of 3 feet from the commission.
But
So
that's a different requirement than this. The commission can grant a variances of both of these if it's within 50 feet. But this building's not within 50 feet, which is why I need a variance from both of them. It's either one applies or both of them applies. You can't have just one. You can't have 6.9, because I looked at this over the weekend. You can't have 6.9 B1 and say B1 applies and not B2. Because if the commission can grant a variance from the 50 feet, then it's going to grant it from both of them. Like either the 50 feet applies to both or it doesn't apply to either. It's not, it applies to one and not the other.
in section 6.9B2, it does know it's for obstructions that shall be erected. They're not actually erecting anything that would obstruct the driveway of their property. If something exists, they're not building what exists.
But there's already stuff there. There's a telephone pole. There's other things there.
Right, but it says that nothing shall be put in there that will obstruct it. It is already existing there. No one's putting it there.
So
They're
then,
moving
but
the
then if the
drive-
neighbor to the south then builds, but then if the neighbor to the south goes and plants a hedge there, he's constructing it after this, and then the neighbor to the north is violating zoning that, and they have to come back for a second variance. The neighbor to the south just planted a hedge. That doesn't
That-
make any sense.
It already exists. I mean, they're choosing to put their driveway where they're choosing to put it.
And what already exists is a telephone pole there. It's an
Right.
obstruction.
That's another obstruction which would have to be moved, I would imagine, if they're gonna put their driveway there. Unfortunately, you don't control whether the pole can be moved. That would be a utility that would determine to move the pole.
Yeah, so we can't grant the variance because we can't order the utility to move its pole.
So that's a determination you would have to make. They're asking for a variance. You would have to weigh whether it can be granted or not.
Lynn, you're going like in a circle here because you're saying we'd have to grant it, but then we can't grant it over the neighbor's property, which is where we'd have to grant it over.
So what we determined is that essentially they're looking for the width of the driveway. The only thing that they're creating is a driveway, right? So it's the width that they're looking for.
And the width is 25 feet at the end. So because the minute the driveway goes in, they're in violation of zoning if they don't have a variance for section 6.9.b.2.
Lynn, aren't they creating the problem because they're putting the driveway right up against the property line? If the driveway came in theoretically at an angle, you could meet the requirement that Luke is bringing up in 6.9B2.
So you would have to make that determination if it's a self-created hardship and they could be locating the driveway elsewhere, but what they're
I
specifically.
don't mean the entirety of the driveway because they're so, they can only put it one place, but the first 25 feet could be angled somehow so that they're away from the pole and the other, whatever other, they have the appropriate distance for access.
Like where the cursor is going, so they should, your view it, and I think someone mentioned that last month, that it should come off at an angle at the bottom.
Yeah, I don't know how severe an angle it needs to be, but at least enough, because how can we grant a variance that creates a problem with something we don't control? If we grant the variance, there's a problem with the pole that's there, and we can't control the pole, and we can't obviously force the neighbor to do anything about it. And one, it's not their responsibility for the telephone pole, and two, we can't grant a variance over their property.
Right, so that, I mean, that would be something that you could discuss when you are determining whether that this is a self-created hardship or an actual hardship, whether they should get the, whether you should grant the variance or whether you should deny the variance.
Okay, let's hear what the applicants have to say. So does anyone have any more questions for Lynn right now?
Lynn, did we get any feedback from our attorneys on this?
No.
So Lynn, it's Becky Walsh. If we granted this variance, could we be creating a future problem for the neighbor if they wanted to put up a fence or, you know, a bush like Luke said or something? Could we be creating, you know, something that where they'd have to go for a variance?
So you'd have to weigh that. You normally you're not like considering the future. You're considering what the applicant put in front of you, and either it's a hardship or it's a self-created hardship, and either you choose to grant the variance or you choose to deny the variance. I mean, at the end of the day, if there's a hardship, it would be a unique hardship with that is unique to this property and different than what would affect the neighboring properties.
Okay, do I need to read that portion, Lynn, that?
Oh yeah, from the agenda, yes, we should.
Okay. 27 Park Place zoning variance upon application of Jacqueline Kaufman, Carmody, Torrance, Sandek, and Hennessy LLC, authorized agent for Rebecca Harris and Eric Schmeltz, owners, for a variance of section 36D4 and 6. Is that a 2B1 to allow the driveway clearance width on the property to be 11.1 feet in lieu of the 14 feet required for property in the B resident zone, map K, block 137, lot H56. So is it Attorney Kaufman? Is that it? Yes. Okay.
Hi, good evening. How are you? Thank you very much. I'm here on behalf of Eric Schmeltz, who's on with us tonight, and also Rebecca Harris. And we had not had an opportunity to hear or learn about any of the supplemental information. I appreciate the time that both staff and the commission or the board members have put into this discussion. However, the Schmeltzes wish to withdraw the application and study this more and have the opportunity to return to you at some point in the future. I think had we known a little bit more earlier today, that may have changed that position, but that's where we are right now. We had provided an email earlier or late afternoon to staff. She may or may not have had an opportunity to see that, but your comments have been extremely helpful for the future planning for these folks for their property, and we appreciate all the time you've put into this matter. Thank you.
Okay, thank you. Okay, so we do not have any other applications. So let us go on to the minutes from the last meeting.
I didn't see any problem with them, but I'm not Ben, so I'm sure he would find one thing. How about you, John?
Anyone else have?
You're on mute, John. John, you're on mute.
Thank you, Richard. I didn't see any problem with them either, Becky. But I'm not the one to step into Ben's shoes.
Okay,
I move that the minutes be approved as submitted.
anyone to second vote that?
Carden can second.
Okay, all those in favor?
Aye.
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 you just, I know it's a pain, but you're gonna take a vote by name.
Cashin in favor.
Mahoney in favor.
Edmonds in favor.
Cardin in favor.
Walsh in favor.
Gary two in favor.
Dull in favor.
Okay, that's unanimous. Any other, anything else the board would like to discuss at this time? Oh, Lynn, did you want to tell us about the November training?
So in November, we're gonna schedule a training with Bertram Moses, the town attorney. And it will be planned to be scheduled a 6 p.m. meeting. So 6 to 7 would be the training, and then 7 would and beyond would be the meeting. And depending on if there's no items on the agenda, then we would just meet from 6 to 7. And if there are items, then it would just the meeting would start at 7 p.m.
Okay, is that okay with everybody?
This is November.
Yeah.
Yeah.
Do you know what will they be talking to us, training us about?
Just, you know, they did a conversation on what the role of the P&Z was about for the P&Z. So it's, you know, the role of the ZBA board members, looking at hardship, some typical questions, granting variances, use variances versus dimensional variances. And then they had a conversation about like when you need to recuse, when you don't need to recuse. It's come up a few times at P&Z. I haven't, and then I'm trying to think, just the basics, state statute and update on case law with respect to ZBA.
Okay, that sounds helpful. That's great.
So that's on November 1st.
Yes,
Okay.
that's right
Right.
before. today.
Lynn, I emailed you the section of that treatise on that same subject. Can you forward that along?
I haven't yet. We got it today, but we can forward it on.
That's kind of intended to answer John Mahoney's question. It's just I didn't want to send anything directly. I think it should
Yeah.
be in the record.
Yeah, you can't, but I can,
So I just copied
I
the
can-
treatise section.
yeah.
Thank you, Luke.
You're welcome.
Okay,
Anyone else can read it if they want. But
what was that, Luke?
anyone else can read it, you know, you can forward it to anyone. I just, you know,
About-
downloaded it,
what
but
was
it was
it?
intended for John's question.
Okay. Okay, anything else?
Hey, Lynn, question on the litigation, is that, what's the update on litigation against the board?
So the Planning and Zoning Commission had a special meeting on September 20th to discuss it. The Zoom is on the town website, and they're going to come back with a resolution. Then once they have a resolution and they vote on it, it'll be forwarded back to ZBA to forward back to the court. So it's there right now, the resolution is being drafted. So it'll be back either later this month before P&Z or in November.
Okay. And the process is just that we just forward it back? We don't have to go through a vote or a consideration or anything?
I'll let town council discuss that when it comes back here. And I think it's just I think it would depend on what they come back with and how you guys already came down on the case, where you guys want to fall.
Okay.
Lynn, yesterday I was driving down Locust towards Route 123, and at the corner of Summer Street, right before you get there, someone built this, 6-foot high stockade fence right in the corner there. It's a corner lot. I think it's in the front yard of both properties. I think it has 2 front yards, the property.
We could discuss this offline.
Okay.
Okay. The meeting, if there's no other matters, then we will adjourn the meeting for tonight. Thank you
Okay.
all.
Terrific. Thank you all.
Thank
you.
you.
Thank you.
Okay. Have a good one.
Bye-bye.
Bye.
Bye.